Rick Brody worked for 18 years alongside the victims of Chad's late dictator Hissène Habré, who was convicted in Senegal and has helped pursue despots such as Augusto Pinochet of Chile, Jean-Claude Duvalier of Haiti, and Yahya Jammeh of Gambia. He has exposed Bush administration torture, led UN missions in Salvador and Congo, and uncovered abuses by the US-backed Contras in Nicaragua back in the 80s. And we have here his latest book, How to Catch a Dictator, which is actually the whole process of how, after 15 years of searching for justice, finally Hissène Habré was brought to trial in a special chamber in Senegal. So the idea of bringing him today was not so much on how to catch a dictator, but the whole process of bringing high-profile people that have been responsible of mass atrocities to justice. I'm also very happy to have him. I admire a lot his work. I'm actually quoting one of his articles that he wrote in 1980. So yeah, you're
1980.
Getting
the
old.
one on disappearances,
yeah.
right? Yeah.
So when I did my PhD on disappearances, he had written some articles on the Declaration on Enforced Disappearances. So I've been following his work for a long time. And today, his talk is about 25 years after Rome and Pinochet, the record of international justice. So from Pinochet until today, where we are. So welcome, Reed, and
Thank
you
you,
can start
Alessandra.
whenever you want. Please sit down and we're starting.
Thank you, everyone. So exactly, 25 years ago, exactly, I represented Human Rights Watch at the Rome conference that established the International Criminal Court. And I recall, as 120 countries voted to adopt the Rome Statute, this feeling like we were really, striking a blow in the quest for accountability in the world. And looking at it 25 years later, I think a lot of people wonder if we were not too optimistic. As we meet here today, the International Criminal Court has never sustained the atrocity conviction of any state official at any level anywhere in the world. Let me let that sink in, because it's something that you do not find on the website of the ICC or virtually anywhere for that matter. In over 20 years, and at the cost of over $2 billion, the ICC has never put away, has never sustained the conviction of not just a head of state, but any state official. The only people convicted by the ICC have been 5 rebels from Africa. All the cases brought by the ICC, the major cases, have failed or not gone anywhere, either because of prosecutorial insufficiencies, because in the case of Kenya, outright sabotage by the targeted officials, or in most cases because the ICC simply can't get their hands on the officials. That's the case of Sudan's al-Bashir. It's the case of Gaddafi, who died. It's the case in South Ossetia, and probably will be the case with Vladimir. Hopefully not, but for the moment, probably the case of Vladimir Putin. So I think we have to. If you look at the ICC website, it says they've convicted 10 people, which even itself people say, oh, they've only convicted 10 people. Well, 4 of those were for attacks on the administration of justice, for witness tampering. 1 was reversed on appeal, which is Bagbo, and the others, as I mentioned, are the 5 African rebels. Now, having said that, I think that having the ICC has made a huge difference in the world. the ICC, I think, expresses and stands for the baseline presumption of the international community in favor of accountability. Today, accountability is the norm for atrocities. And I mean, it's the stated norm, and it's not the actual what happens. But any case in which there is not justice is not in which there's not accountability is seen as wrong. It's seen as an injustice, and I think that's in large part because of the ICC. There's also the ICC. The statute of the ICC, the Rome Statute, has been incorporated into the legislation of dozens of countries who have now criminalized crimes against humanity, genocide, who have now put in their national legislations the obligation to prosecute people who've committed those crimes. The ICC has established a series of best practices, most recently, or especially really, but also most recently, on issues relating to gender justice and crimes against women and sexual violence crimes that have been the product of a lot of international debate and have influenced how these crimes are looked at and prosecuted internationally. We also have the ICC Prosecutor's Office, which has pressured a lot of countries, particularly I think of the case of Guinea, where recently the former head of state, Dadis Camara, went on trial for a stadium massacre. I think it was 2008 or 2009. 2009. And that was a case where the ICC had been working with the Guinean authorities, pressuring them. The same thing to Colombia, where the ICC's investigation on Colombia was instrumental in pushing Colombia towards the transitional justice program it has now. In the case of Hissène Habré, Hissène Habré would not have been brought to justice had it not been for the ICC. Why? Because the African Union invested in the Hissène Habré case because they wanted to get the ICC off their backs. They wanted to show the ICC that it didn't need to send African leaders to The Hague, that African courts could prosecute African crimes in Africa. And that was, it was explicit, but it was also very, it was a very tangible motivation for the African Union, and the Habré case would not have happened without the support, ultimately, of the African Union. The Habré case, though, was actually really the product of the other event that we're celebrating 25 years of, which was the arrest of General Pinochet. As you all know, Augusto Pinochet, the former president, dictator of Chile, was arrested in October 1998, a couple of months after we'd come back from Rome, on a warrant from a Spanish judge for crimes that had been committed 25 years earlier in Chile. Under the rule of universal jurisdiction, the idea that some crimes are so heinous that that countries have the right, and in some cases under treaty the duty, to prosecute their authors no matter where the crime was committed. And Pinochet, of course, challenged his arrest before the British courts. I participated for Human. I packed my bags for London for a couple of weeks, and I ended up staying for the better part of 6 months, as the case went twice or three times, really, to the British House of Lords, which at the time was the Supreme Court. And when the House of Lords ruled that Pinochet, despite his status as a former head of state, did not have immunity from prosecution and extradition, that was really it was a champagne moment, as we say. You know, at the time, as a human rights lawyer, this was 25 years ago, I was used to being right and losing. And here in the Pinochet case, not only did we win, but we won, you know, this case against the iconic Latin American dictator. You know, I remember coming out, I mean, we had prepared this, of course, for Human Rights Watch. Coming out of the House of Lords and saying this was a wake-up call for dictators, which was a great pithy quote that we all loved, but that's really not true. I think, you know, really, but what it was a wake-up call for activists and for victims around the world. And, you know, in the wake of the Pinochet case, you had this real, what Catherine Sikink called a justice cascade. And in country after country in Latin America, you know, where arrangements had been made with the ancien regime, you know, there had been no prosecutions. And in country after country, Guatemala, Chile, of course, which I should have mentioned, that Pinochet did go back to Chile, but he went back to a very, very different Chile, in which hundreds of cases were filed against, including against Pinochet, and he died under house arrest. But also Guatemala, Argentina, El Salvador, and you know, the victims' thirst for justice had not been extinguished by these transitional arrangements, and so with Pinochet, the Pinochet case behind them, and that precedent, there was this wave of justice throughout Latin America. But also this idea of universal jurisdiction. We realized with the House of Lords decisions, including the second decision of the House of Lords that was based on the Torture Convention, that we had a new instrument in universal jurisdiction to bring to justice those who seemed out of the reach of justice. And really there was an effervescence in the human rights movement at the time. And we had all these meetings with Amnesty International and FIDH and other groups, like who's going to be the next Pinochet. And we had really, you know, we had really high hopes for how this was going to turn out as well. It didn't. We always knew that it was going to be very difficult, that the political status quo was going to be very difficult to break. I mean, even in the years after Pinochet, we tried when Mengistu of South Africa of Ethiopia went from Zimbabwe, where he'd been living, to South Africa. We worked with South African groups to try to get him. The ANC didn't want any part of that. One of Saddam Hussein's right-hand men, Izzat Ibrahim El-Dori, was in Austria. Austria let him go back to, and so on and so forth. Idi Amin in Saudi Arabia. I actually met with the Saudi ambassador to Geneva on behalf of South Indian victims of Idi Amin's regime. And we were told that under Bedouin hospitality, when you let someone into your tent, you can't ask them questions, which is not true. But anyway, that was the kind of status quo that we were up against. But we were approached by, we were looking around the world to see who else this precedent could be applied to, and that's how we were approached actually by the Chadian victims of Hissène Habré, who said, we have someone who has done worse than what Pinochet did, and what interested us really was that that Hissène Habré was in Senegal, and that this was, in addition to everything else, an opportunity to bring the idea of universal justice to the global South. And if we could get Senegal to prosecute Hissène Habré, this would have kind of broken the idea that it's only, the Spains and the UKs and the Belgiums of the world that can do this. I'm not going to go into the 18 years that it took us to bring Hissène Habré to justice. You'll just have to read the book. But it ultimately, Hissène Habré became the first, actually the only time, the only case in history in which a a former head of state was prosecuted by the domestic courts, so it was a hybrid court of another country for human rights crimes. But really there was a very fallow period for universal jurisdiction until recently, what Philip Grant from Trial International calls universal jurisdiction 3.0. So after several years of really very, very few cases, now there are a lot of cases of universal jurisdiction. I mean, there were 23 convictions last year. According to Trial International's annual report, some 169 suspects currently being investigated in crimes in places like Syria, Myanmar, Liberia, Iraq, Rwanda. And it's the result of, on the one hand, NGO activism, which I'll talk about in a minute, but also a lot of countries, particularly in Europe, mostly in Europe, in fact almost exclusively in Europe, have created these war crimes units within their police and prosecutorial, and in the case of some countries, within their judiciary, who specialize in universal jurisdiction cases. And some of them have opened what are called structural investigations. So in Germany and in particular, but in Sweden as well, they have structural investigation into the situation in Syria, so that if a presumed Syrian perpetrator comes into their country, they're ready to bring a prosecution. There are also, very interestingly, these 3 international investigative mechanisms that have had a huge, they're not well known, but they're these UN-funded or internationally funded investigative mechanisms for Myanmar, for Syria, and for ISIS, for Daesh. And these were begun, actually the Syria one was begun because they couldn't bring Syria to the ICC because Russia and China vetoed it. And so they created this independent mechanism. And what these mechanisms are doing, very interestingly, is that they're preparing cases. And so they prepare these files and they give them to prosecutors. So the Swedish prosecutor has people from ISIS in Sweden and gets files on these people from the independent mechanism. There's a case that I thought when it was brought was incredibly quixotic of crimes from Myanmar that was brought in Argentina under universal jurisdiction. And the first instance, Argentina just said, how am I going to investigate the crimes? And the international mechanism for Myanmar says, we'll investigate them for you. And so the case, actually, his dismissal was reversed on appeal with partly with that argument. And you have witnesses going to Argentina, and so there's a move now, sponsored by the International Commission of Jurists, to have a permanent, a standing international mechanism that wouldn't just take these 3 cases, but would investigate all situations of mass atrocities. Obviously, there are a lot of political questions involved because certain countries don't want certain countries investigated, and certain powerful countries, let's say, don't want certain countries investigated. But what is interesting and what I'm describing is that 25 years after Rome and Pinochet, you have this very, very vibrant international justice ecosystem. It's just not at the International Criminal Court. I mean, you have, and what's interesting about many of these cases that are happening is that they were built by activists and victims. You know, in the Habré case, you know, we worked, I mean, the people at Suleiman Gengeng, a Chadian accountant who was thrown into jail and promised, as people were dying around him, that if he ever got out, he would fight for justice. And when he came out, he started documenting these crimes. And he became the driving force behind this case. And then NGOs, I mean, Human Rights Watch, came in and we started, you know, investigating. And as I don't know if Christoph Sperfeld is here, but he wrote that, you know, we handed the case to the judges on a silver platter. The same thing if you look in Guatemala, the prosecution of Rios Montt. You had NGOs, indigenous organizations working with NGOs who basically prepared the case and ran the case. And these cases are handled and run very, very differently than cases have been prosecuted by the ICC. Because essentially the affected communities, the victims and their allies have been in charge. And they, as I always quote this passage from Nomi wrote Ariadza, who wrote a book called The Pinochet Effect.
Yeah.
And she looks at why these cases like Rios Montt and the cases in Chile and the cases in Argentina and the Hissène Habré case are so much more impactful. And the reason, she says, is that these cases, that these are victim-driven, that they stirred imagination and open possibilities precisely because they seem decentralized, less controllable by state interests, more, if you will, acts of imagination. And when we were preparing the Hissène Habré case, we watched the Rios Montt trial. Pam, these two filmmakers, American filmmakers, did these wonderful videos called "Bringing a Dictator in the Dock," which showed how the Rios Montt trial proceeded. And this was exactly what we were trying to do. And so, just the same way that the Chadian victims came to us and said, we want to do what Pinochet's victims did. And actually, when we finished the Habré case, we all went with a bunch of leading victims, Suleiman, who I mentioned, the lawyer, Jacqueline, and some others. We went to Gambia, where the dictator of Gambia had just left the country, Yahya Jammeh, and we met with the victims of Yahya Jammeh, and they said, we can do that, and so there's this real feeling. I mean, anybody in this room can do what we did, essentially. I mean, you can't be the prosecutor of the ICC, you can't get states to fund, but you can, a lot of cases now, there's a group in one of the lawyers actually who was working with us on the Habré case, Alain Werner, now runs an organization in Switzerland called Civitas Maxima that focuses on Liberia. And he has a database of all the Liberian, well, not all, but he have Liberian perpetrators. And he and his team, working with Liberian activists, have been behind cases that are now, just a few months ago, one Liberian warlord was convicted in France, another was just convicted in Switzerland. And so these are cases that are being brought by civil society activists. They look very different, very different. The first cases by the ICC prosecutor, when he went into the DRC, millions of people have been killed in the DRC, Democratic Republic of Congo, and his first case, and civil society was so excited that this was the first case. And who does he indict? He indicts a warlord for child soldiers. Now, child soldiers is a bad thing, and I have to say that one of the things that we can thank the International Criminal Court for is making that into a recognizable international crime. But still, it really minimizes the gravity of the situation of millions of people dying to go after a local warlord for a crime that is horrific, but it happens like in every conflict in Africa. Sorry, and when we worked on, in the Rios Montt case, they had an idea of exactly how the community wanted the case to look like. In the Hissène Habré case, Habré had slaughtered Muslims from the north and Christians from the south, and the victims were very clear, this has to cover all of the atrocities that were committed. So, this is this is, I think, really the justice that's happening today happens on the national level, happens on the hybrid level. Now, a lot has changed in the last year. The Russian invasion of Ukraine has really created a Ukraine moment, or some would say a Nuremberg moment for international justice. I mean, you have this massive justice response that has, by orders of magnitude, outpaced anything else we've ever seen. I mean, you had within the Ukrainians, and I have to say, the Ukrainians deserve a lot of credit for trying to fight back, not just militarily, but with justice. And the Ukrainian war crimes prosecutors have opened tens of thousands of cases. In the middle of all of this, they are using a lot of resources to document crimes and to put justice on their side. The ICC, opened within days, had gotten 43 countries to request an investigation and opened up its biggest investigation ever, and has raised all of this money from Western countries for its investigation. And of course, a couple of months ago, issued an arrest warrant for the president of Russia. I mean, to have an arrest warrant against a sitting president of the Security Council, permanent member, who's not even a state party to the ICC. This is certainly the boldest reach ever of international justice. And this is the kind of response that we would like to see everywhere. And I think, that is kind of the problem here, is that at the same time that this is heartwarming to see how everybody is now thinking about justice and about war crimes, so far in the 2 years, or the year and a half since the invasion, you haven't really seen that, transfer to other situations. There's a lot of, a lot of concern that there always has been about double standards at the ICC, and we know that the prosecutor, deprioritized the investigation of the Bush torture program in Afghanistan. The previous prosecutor, Fatou Bensouda, had dropped the investigation of British war crimes in Iraq. There's a question really as to, whether, the ICC is willing to go up against its main state sponsors. I shouldn't blame this all on the ICC, because the double standards in international justice go much further than the ICC. The two broadest laws on universal jurisdiction used to be Spain and Belgium. And the Spanish law was great for Latin Americans, and it was great for people from the Western Sahara and for El Salvador. But once it started being used against China, Israel, and the United States, the law was, I think you've written about this, and the law was basically abridged. And the same thing, I was living in Belgium. In fact, the Hissène Habré case at the time was in Belgium when, and the Belgian law was great when it was being used against Rwandans and other Africans and Hissène Habré. But when it started being used when a case was filed first against Ariel Sharon for the Sabra and Shatila massacre, and then against George Bush's father. I was in Belgium when Donald Rumsfeld came to Belgium and said, if NATO leaders cannot feel like they can come to Belgium without being arrested, then maybe we'll just have to move NATO out of Belgium. The Belgian law, one of the chapters in my book describes this, and the chapter is called A Banana Republic, because this guy from the Ministry of Justice in Belgium said, now I know what it feels like to live in a banana republic. He said the Americans, they not only ordered us to change the law, but they stood over us as we rewrote the law to make sure it was okay. I mean, I could go on and on. I mean, Germany, which has done really the most aggressive work on universal jurisdiction, particularly the prosecution of Syrian torturers. When we filed the case against people from the George Bush administration for torture in Germany, they weren't interested. Nor was France, and ultimately nor was Spain. And of course, nobody's still prosecuted anybody from the Bush administration for torture. But really, when people talk particularly at the ICC about double standards, the thing they most often talk about is Israel-Palestine. I mean, the ICC has jurisdiction over Israel-Palestine, over Palestine anyway, because Palestine as a state has requested an investigation. As far back actually as 2009, took 6 years for Palestine to be recognized as an ICC state party. In 2015, then the case has been slow walked for 4 years. Fatou Bensouda basically approved the investigation on her way out and left it for Karim Khan. And Karim Khan has, as far as we can tell, not really done anything. And he was even silent when Palestinian and Israeli NGOs, Palestinian NGOs who provide information to the ICC were shut down by Israel, which is normally a case where the prosecutor does say something. So, I mean, this mobilization around justice is very heartwarming for Ukraine, but it needs, I think we need to, welcome that. I think we can't be churlish about that. Ukrainians deserve justice. What Russia is doing is horrible. But we have to always point out that this needs to be the example rather than the exception. A couple of weeks ago, Henry Kissinger turned 100, and it gave me a lot of gave a lot of people room to think about war crimes. I think if I ask people in this room, Henry Kissinger is most people would say war criminal. And so I did for the Just Security blog, I actually did an analysis of whether he is actually a war criminal. Because it's very easy, I think, to conflate, moral, historical, political responsibility for millions of people being killed with actually being a war criminal. But and I have to say this started about 20 years ago when I was teaching a class at Columbia Law School with Michael Ratner, and we were looking at this, and I had students actually look at the different episodes that Kissinger was involved and other people were involved in. And of course, a lot has come out since then, but there are at least 3 cases in which I can say that Henry Kissinger has a case to answer for being a war criminal. One, and I know there are a lot of Cambodia people here, certainly is the bombing of Cambodia, where Kissinger was, Kissinger said, anything that the order is anything that moves, anything that flies on anything that moves. In other words, we don't care if they're civilians, we don't care if they're military. And Henry Kissinger was directly involved in the selection of bombing targets. We know he read the raw intelligence, he read the data. He even though he wasn't in the defense chain of command, he was directly involved in that. Another area, much less well known, is the war between Pakistan and East Pakistan, in which the United States not only there was an election. Pakistan used to be two divided country. There was an election. Guys from the East won. Yahya Khan, the military head of the country, said didn't want that to happen. He invaded East Pakistan. They're strafing villages. They're going after targeting Hindus, who comprise 10% of the population, tens of thousands of cases of rape. The U.S. supporting the Pakistani military. American officials in Dhaka, in East Pakistan, what is now Bangladesh, are reporting back about all these atrocities, pleading with the American government to get off the side of these genocidal killers, as they called them. The U.S. ambassador to India, who had been pleaded with the White House directly with Nixon and Kissinger. They laughed it off. They fired the people. And they arranged to have arms from third countries, since America couldn't directly be giving arms at that point, given to the Pakistani government. This is what's known as a classic case of aiding and abetting. Many of you will know that Charles Taylor, for instance, the president of Liberia, was convicted by the Special Court of Sierra Leone. Even though he'd never been set foot in Sierra Leone, he was convicted for aiding and abetting the rebels, because he was aware that they were using his arms and his support and his to commit atrocities. It's like, and that describes what Henry Kissinger's responsibility would be here. It's like a guy is out on a shooting spree, going around killing people, and he runs into your store, says, "Quick, I need more bullets," and you give him more bullets. Another situation would be East Timor, where on the eve of the Indonesian invasion of East Timor, President Ford and Kissinger met with Suharto in Jakarta, gave him the green light. 90% of, I should have also the same thing with Pakistan, where 80% of Pakistan's arms came from the United States. In this case, 90% of Indonesia's arms came from the United States. As I'm sure all of you here know, up to a quarter or a third of the Timorese population was killed with American arms. The only question I would have, and I point out in the article I wrote about this, is we don't know how much Kissinger actually knew in real time about the atrocities. But these are instances where somebody like Henry Kissinger could be, called into account for war crimes. And now, of course, all of this happened before the heyday of international justice, before the ICC, before Pinochet. But it's very interesting that in those three situations, Cambodia, East Pakistan, Bangladesh, and Timor, tribunals have been set up, actually, to look at atrocities. But in each case, and people here who know much more about Cambodia will know that for the U.S. they were never going to permit that the Cambodia tribunal look at the American bombing campaign of Cambodia. The East Timor tribunal never went back before 1999, and the tribunal in East Pakistan or in Bangladesh did not look at people who were not in the country. But it just shows, and I just take that as a real example of, international justice has come a long way. But for Henry Kissinger to celebrate his 100th birthday and never having to answer to a judge for anything shows how much further we have to go.
Thank you very much. We have some time for questions or comments. So, does anybody want to? Yes? Okay. Can we have the micro? Can you raise the hand so she knows?
Thank you very much for mentioning Bangladesh. So I would say that instead of East Pakistan, we love to hear Bangladesh because it is a position of international law and other states that recognized us, including Pakistan. So my question is about the immunity, because as you can see, maybe we are a bit lucky generation to see a lot of international criminal institutions, unlike you. But what we are still facing, even after the watershed moment of the Pinochet, there is still the question of immunity. And that has been illustrated by al-Bashir and different and conflicting decisions of the ICC. And maybe the world is going to face it again with the Putin case, if it goes against for cooperation for immunity and other questions. And ILC, unfortunately, is also very unsettled on this issue of immunity, Article 7. So what's your view on that? Is the institution enough if we don't have a very good basis for or against immunity? Thank you.
Can you give to next to you on your right?
Thank you very much for excellent thoughts. My name is Tony Chidavira, and I would just love to hear your insights on an issue that also might be of interest to some members here, of course. You've been talking about the double standards and in the way that international crimes and cases are approached. And this particularly relates to an incident in Ukraine a couple of months ago when there was a report by, I think, Amnesty International detailing incidences, amongst others, of government soldiers using a school as a base in one of the cities. And on account of that, there was a lot of criticism. I think even the director of Amnesty in Ukraine had to resign. But also there was a widespread criticism from states, from NGOs, that the organization was sort of doing propaganda for Russia. So I would like to hear your thoughts from your huge experience on whether you have encountered any such instances. Thank you so much.
Instances of?
Instances where you have had to actually pull out of an intervention simply because you feel that your report is being disregarded because you are perceived as maybe biased, or you are perceived as doing propaganda for a state, and on that account you have actually put a hold on some of your interventions. I don't know if that makes sense.
Sure.
But also if you could comment on the instance of Amnesty in Ukraine and the report where the director had to resign. Thank you.
No, it's okay. Sure. I mean,
Yeah.
well, let me answer the immunity question first, because I don't really have a. I'm sure there are a lot of people in this room who know this issue, who understand this issue better than I do. Obviously, the question of head of state immunity is not resolved in many ways. I think the ICJ decision in the arrest warrant case. I was actually, a couple of years later, Belgium. I was helping the Belgian. The Habré case went to the ICJ, and Belgium took it to the ICJ. So I'm very close to and I love the Belgian government for what they've done. That was first of all, in my view, that was a really bad case to let go to the ICJ. I mean, you need I think a lot of time, you really need as an advocate, as an activist, to understand the fora that you're going to and to be strategic about how you conduct litigation. The Pinochet case in 1998 was such a high watermark, and very clear decision by the British House of Lords twice on two different separate grounds of why he did not have immunity as a former head of state. But to allow a case of a sitting head of state to go to the ICJ, which is traditionally, although it's changing, traditionally been, a very state-oriented body with, former foreign ministers and justice ministers and juriscouncils. It was really a recipe for disaster. And of course, the ICJ, in its decision, said that sitting heads of state, as well as sitting foreign ministers and prime ministers, have immunity before domestic courts. And then there's a famous paragraph where they list, and actually what happened at the time that decision came down, we were trying to prosecute Hissène Habré, there was dicta in that case, in that paragraph in particular, that said even former rulers have immunity. And so that tended to put me out of business, right? I mean, Hissène Habré, anybody, all these people. And we actually got in the Habré case, we actually put pressure, and we got the government of Chad, because one of the exceptions was if the country that person used to represent waives that immunity. And so we got the government of Chad to waive Hissène Habré's immunity, which is what allowed us to continue all these ways. But that decision stands as law. Now, it doesn't, there are a lot of unanswered questions. It doesn't talk about the conflict between potential treaties, with the Geneva Conventions, with the Torture Convention. As many of you know, there's also a question as to whether, as to Article 98 of the International Criminal Court statute that says that a state doesn't have, that the state's obligations to the International Criminal Court have to give way in the face of bilateral obligations to other states. And then the question is, well, let's say take a case like Vladimir Putin. If he travels to a state party, is that state party bound by its obligations to the ICC, or is it bound by its bilateral obligation under customary international law not to? But I don't have the answer to that question. Chile was here yesterday. You could have asked him. But I don't know the answer. Obviously, immunity has a place. Chaos cannot reign in international affairs, and you want people to be able to conduct diplomacy. There's a question as to where that line should end and where atrocity accountability should begin. In terms of the Ukraine report, I did not do my own investigation, so I can only say what colleagues who I respect say. Amnesty, the principle is correct that Amnesty was talking about. I know a lot of war crimes experts who felt that Amnesty was too hard on the Ukrainian government, that when you're defending when you're defending a city, it's hard to put your defenses in a place other than in that city. That said, I know that Amnesty is not biased towards Russia. 95% of their reporting on the conflict, because 95% of the war crimes have been committed by Russia. Ukraine has committed, again, I haven't investigated these things, but Human Rights Watch and Amnesty have found that there have been war crimes on the Ukrainian side. And I mean, I think that the decision this week by the United States to give cluster munitions to Ukraine is like,
No.
I mean, you know, and to have the State Department or to have the United States defend this decision by saying, you know, ultimately we're saving Ukrainians from worse war crimes to be committed by Russia, and Ukraine is defending itself, and Russia's, I mean, this is total confusion between jus in bello and jus ad bello, and between fighting a just war and fighting with just means. I just think it really sets the cause of the inviolability of human rights. I mean, it's not illegal to use cluster munitions. I mean, the United States, Ukraine, and Russia have not signed on to the convention. They're not using it in civilian areas. They're using it against soldiers. But of course, as we all know, these bomblets remain for a long time, and do provide civilians. So I feel it's really unfortunate when you're trying to be on the side of the angels, and you're trying to, and a country as influential as the United States, to basically say, well, you know, we have to give them these weapons because they have to defend themselves. I just find it very unfortunate.
Okay, so I guess the judge Chile wants to reply or make a comment on the immunity.
Oh, Chile is here. Oh, Chile is there. I didn't see you.
But because he's not wearing a suit today, that's why you couldn't recognize him.
I didn't know you were here, Chile.
Thank you very much. Looks like I can't escape. Reed, that was a very nice talk. I will, first of all, I've known Reed Brody for a long, long time. So we're on first names. And over the years, we've agreed on some things, and we've also had moments where we thought we could, you know, have different views. And one of them would be, now, your opening about the ICC. Saying the ICC has not, and began strongly on that note, convicted any officials or sustained convictions or officials. We can disagree on the view of the mandate of the ICC in that regard. How we see the function of the ICC as a former judge of the ICC, I speak for myself, is that the ICC is a court of law, and being a court of law, there are standards that it must respect in the administration of justice, regardless of who is indicted, be it a warlord, be it the, you know, keeper of the gate at a concentration camp, or be it head of state. The standard of justice remains the same, and that is no one may be convicted of a crime unless the judges are satisfied that the evidence against that person has been established at what we call a standard of proof beyond a reasonable doubt. The idea is that the ICC cannot be a place where people fear justice, in the sense that once you're in doubt, all that needs to happen is that there is an indictment against you at the ICC and you cannot get out of it. The idea is the indictment is a starting point, and everyone who's indicted enjoys what we call a presumption of innocence. And then the prosecutor, in order to convict that person, must establish the guilt of that person beyond a reasonable doubt. That cannot be changed, and the judges are not apologetic about that, even if it results in acquitting people or reversing people whose convictions have been obtained at the lower level. So that's how we see that. I mean, sustains the legitimacy of the ICC in the long run. Right. Now, but you're also correct in pointing out that despite your grievance in that regard, you do see value to the ICC in terms of accountability, and that is what the thing is about, really. Accountability, as we see it, is that somebody is held accountable, so they have to come and give account of their conduct. Giving account does not mean punishment invariably. It means you answer questions. There was a time before the ICC when it was beyond contemplation that certain persons may be charged before crimes. But now we take for granted, well, people may be charged for crimes for the ICC, and there's a lot of value in that. And when you talk about how this norm of accountability has now taken hold, let me relate that to a question I answered yesterday about the gentleman who asked the question, how many genocides have been avoided. I used the opportunity to talk about how we see justice. Now, I did not finish that. Now, you've given me the opportunity to finish that answer. And the answer was this. The complete answer was, even at the plane of accountability, it does resonate. People are now, we are seeing deterrence value of the ICC. When I was at the court, I met many heads of state and ministers who told me, thanks to the ICC, we now do elections more responsibly. We tell each other during elections that there should not be electoral violence. See what happened in Kenya? We don't want to end up at the ICC and pat us out to dampen or suppress the incidence of electoral violence. I received that testimony firsthand, and there are some academics who are actually doing work in that regard. You mentioned Professor Siking at Harvard. She and some colleagues have been doing work in that regard. That shows the value of accountability that ICC has helped to sustain around the world. So moving away from that now to the question of immunity. You talked about, someone said that at the ICC the question of immunity is not resolved, there are still conflicting decisions. That is not the case now. And the reason is yes, there was a time before 2019 when first instance courts at the ICC pre-trial chambers had indeed issued conflicting pronouncements on the question of immunity, whether heads of state enjoyed immunity in customary international law. But in 2019, for the first time, that question came to the appeals chamber of the ICC for the first time, and the appeals chamber of the ICC definitively resolved it for purposes of the ICC. And then the answer that the appeals chamber gave was that in customary international law, there is no immunity for even heads of state. Now, I have, since leaving the court, taken up that question. There is a book I have coming out next year on that. But you don't need to wait for the book first. When it comes out, look for it. But in the meantime, if you Google my last name and put just security, just security immunity, right now you see a shorter version of that discussion on the website of Just Security. So there is no immunity for heads of state in customary international law. We can leave it at that, and I don't need to give a long lecture on that too. Thank you.
Okay. There's some questions we had. Okay, you.
Hi, Aurum Chavez. I have a question. Well, the rules of being a member state of ICC is very clear. A country has to, well, agree on being a member of ICC. But what about a nation who is within a country that does not want to be or is a member of ICC, but they're genocide. I'm talking about the Kurdish people. There is no, ICC cannot help us right now with especially with our historical genocides. What is the best solution for us, or which organization or which tribunal is the best for us to help, help our victims and our genocide survivors?
One more over there.
Thank you.
Hi, Mr. Brody. Thank you very much for everything. I want to ask if during the Pinochet trial, did you experience some of the Chilean diplomatic pressure for getting General Pinochet released? Thank you.
Okay, we will take one more. Yeah.
Thank you for the presentation. You have mentioned all of the difficulties to apply universal jurisdiction, and it's and basically the difficulty maybe to reach the high echelons, for example, and with states that do not, that have power and could prevent the use of universal jurisdiction. But what would you say about shifting the efforts towards maybe what is now the initiative of the Ljubljana Convention on Mutual Legal Assistance, and maybe in this way getting more states that are not willing to collaborate with universal jurisdiction, but that will be then less frightened or will be willing to collaborate with supplying mutual legal assistance, and in that way fighting, being more successful with the fight against international court crimes.
Sure, thanks. These are all great questions. Let me just briefly respond to Chile. Obviously, we have no quarrel about the standards for prosecuting and convicting. So you're right, the ICC's role, the ICC, particularly the judges of the ICC, role is to weigh the evidence and to convict the people who are found guilty beyond a reasonable doubt through admissible evidence. It's not the judges. I actually think there's this, in retrospect, there's kind of a structural flaw in the ICC, which is the distance. That there's one of our colleagues uses distance as a that's, it's very difficult for the ICC to compete with the president of Kenya, who controls the territory, who controls the witnesses, who controls the crime scene, and I think ultimately what we're seeing is basically, it's not the problem whether people are convicted or acquitted. The problem is really first is the ICC getting its hands on getting their hands on people. In certain situations like Côte d'Ivoire, it was able to get its hands on people, but in most situations the ICC is just not able to capture people. But I also think there's a structural problem in terms of, and of course Ukraine is an opportunity for the ICC because it has, maybe it can't get its hands on the Russians, but it has access to the territory, which is something it doesn't have, say, in Palestine or in other places. So I think it's a combination of many factors that has led to what I call, and obviously the rebels cases are very important. And they've all, in their own way, contributed to jurisprudence on child soldiers, on sexual violence, on cultural heritage, and things like that. But one can ask whether it was necessary to establish an international criminal court in order to prosecute rebels. But I do, as you said, I mean, I do believe that the ICC was worth it. I mean, I hope that, I don't know if that came through, but I do believe that we wouldn't be where we are today in terms of justice, what you were saying, had it not been for the ICC. So the Kurdish genocide, you know, actually before I joined Human Rights Watch, or actually just around the time I joined Human Rights Watch, it was on this campaign to try to get a state to take Iraq to the ICJ under the Genocide Convention. And ultimately, it was not able to find states who were willing to do that. I think today we see a lot more activism at the ICJ. We saw Netherlands and Canada just take Syria under the Torture Convention. We see obviously Ukraine using the ICJ. We've seen a lot of genocide. I mean, we've seen obviously the Bosnia case that Chile talked about yesterday. You know, in terms of universal jurisdiction, I briefly mentioned one case, the case of Izzat Ibrahim al-Duri, right? This is a man whose signature and seal are on orders to use chemical weapons against the Kurds. And he was in Austria, I think in 1999, and the case was filed against him. And he was getting medical care, and Austria allowed him to go back to Iraq. And then he ended up fighting with ISIS, I believe, and then dying a year or two ago. I would say, you know, if that's the way you should do, find these people, find where the other Izzat Ibrahim al-Duris are. Maybe there's one in Germany. Maybe there's one in Spain. You know, maybe, I mean, you know, find them. Use this, and I mean, it depends what your goals are and what you see as justice and what people want to do. But you know, I look at kind of the Civitas Maxima model of what are doing. Find the Liberians or find the Syrians where they are today. Find them, bring the cases, go to prosecutors' offices, you know, campaign. I mean, that's what I would think about doing. Yeah, and the Pinochet case. I mean, the government of Chile, of course, was in a very difficult position because this was I think it was the Democratic Christian government at the time. I forget. You know, who were against Pinochet. But there were, you know, Pinochet had built in Chile a wall of immunity around himself. He had a senatorial immunity. He had, there was an amnesty law. And the government of Chile was kind of stuck. And they put on a lot of pressure. In the first, so as you know, the case went to the House of Lords once. There was a great ruling by the House of Lords based really on customary international law that said you don't have immunity for these kinds of crimes. That case was vacated because one of the judges had ties to Amnesty International. It went back to another hearing, and in the first hearing, Chile actually, and in the final hearing, Chile intervened. So there were lawyers from Chile defending Pinochet's immunity. And then after they lost, they kept fighting to try to get Pinochet back. But this was obviously a contradiction for the government. But as I said, what was very interesting to me was that when, you know, I mean, Chilean society was very, obviously most people in Chile wanted to see Pinochet prosecuted, or that seemed to be the case. But so many were embarrassed that this was happening in England and not in Chile. And so when Pinochet went back to Chile on health grounds, right, because ultimately spent a year and a half in jail, that was the deal that ultimately Chile, the government of Chile, not Chile, the judge, got him back on health grounds. But by then, judges in Chile had looked at the amnesty law that was, I think, a 1978 amnesty law, 79 amnesty, and said, well, wait a second, all these people are still disappeared. So the crime continues today, and it's not covered by the amnesty law. And that's how they were able to go around what seemed to be his armor. And also did a lot of great work for international jurisprudence, because now it is commonly understood that disappearances, enforced disappearances, are continuing crimes until the whereabouts of the person is declared. So, you know, and I think that my colleague Roberto Garraton, who recently died, who was part of our legal team in London, who was the head of the Vicaria of Solidarity in Chile, he said, you know, it was really the arrest of Pinochet that allowed our transition to democracy to move forward, because up until then he had been protected. And he came back and he was no longer protected. Cases mounted. They were able to find out what happened with all his money in Riggs Bank in Washington and everything, and it really allowed Chilean democracy to consolidate. The Ljubljana Treaty, I was thinking about talking about the Ljubljana Treaty because, for those of you who don't know, about a few weeks ago, a international treaty was adopted on mutual legal assistance for atrocity crimes. And as anybody who's ever practiced in this area knows, one of the great problems is international cooperation. You know, I mean, in the Hissène Habré case, which ended up being between we had a Belgian judge at a certain point going to Chad, and to get documents, the Belgian judge, there was no treaty between, there was not even a Belgian embassy in Chad. And so the Chadians had, when they wanted to send something to Chad, he had to send it, you know, you have the judge who sends it to the justice minister, who sends it to the foreign minister. The foreign minister then sent it to the Belgian embassy in Cameroon, who gave it to the Chadian embassy in Cameroon, who sent it to the Chadian foreign ministry. It's like, and it's a serious problem in international cooperation. And now a lot of regions, I mean, Europe has solved that problem. Eurojust is an institution that takes care of these things. But for people who aren't subject to treaties, it's a huge problem. And so recently in Ljubljana, I think there were 80 states represented in Ljubljana, approximately, adopted a treaty on mutual legal assistance for these kinds of crimes. And depending on how many states ratify it, and it could make things much, much easier. What?
You got it all.
I got it all.
Well, thank you very much.